If a person files a late notice of claim and alleges merely that an employee of the city has actual knowledge of the essential elements of the claim, is that sufficient to allow the late notice of claim to go forward? To find out, you have to read Jamie versus City of New York and Orozco versus City of New York, but it's 23 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Jamie versus City of New York and Orozco versus the City of New York. The citation for this case is 2024 New York Slip Opinion 01581, published by the New York Court of Appeals on March 21st of 2024. The issue in this case is the notice of claim statute and whether knowledge by a public employee creates actual knowledge on the part of the municipality, that you can impute that knowledge for the purpose of getting around a late notice of claim filing. I'll explain all that in a few moments. To understand and appreciate the context of this case, what you have to know is that under general municipal law, you can file a claim. A person can file a claim against a municipality, a county, a city, a town, a village, a fire district, or a school district. You can file an action against them, but there are special rules that apply to filing against a municipality. You have to file a notice of claim within 90 days of the action accruing. Within 90 days of when the action actually accrues, when it's capable of being filed, you have to file a notice of claim informing the municipality of the claims you're going to be filing, giving them a chance to investigate it, a chance to order a physical examination or a deposition or an oral examination. But there are special rules even about whether, so that 90-day rule is required, but you can file a late notice of claim. You can request from the court leave to file a late notice of claim, which is discretionary with the court. But if you're going to file a late notice of claim, you have to explain under a multi-factor analysis why you're filing late notice of claim. The most important factors are whether there's actual knowledge on the part of the municipality, whether the claimant was an infant, mentally or physically incapacitated. There's a whole bunch of factors that are in the statute. Whether the important factors are whether there's actual knowledge on the part of the municipality, whether there's substantial prejudice based upon the late notice of filing. And those are some of the factors you have to consider, and the judge has to consider when using their broad discretion as to whether to allow the late notice of claim to go in or not. And it's reviewed on an abuse of discretion standard. Okay, that's the background. What are the facts in this case? The facts are there's two different cases. There's Orozco versus City of New York and Jamie versus City of New York. In Orozco claims that in July of 2018, officials from the New York City Police Department and DA's office engaged in some kind of a conspiracy to engage in malicious prosecution, wrongful detention, and false arrest. He claims that the police officers knew what they were doing, and under the notice of claim law, which has to be filed within 90 days of the action accruing, he was released from jail in December 2018. He didn't file anything until July of 2020. That's when he filed his application for a late notice of claim. So he alleged in that late notice of claim application that the police officers who were involved, they know what they did, and therefore the city should know. The city should be imputed with their knowledge. They know that they did something, and therefore the city should know what they did. He also claimed that there were records that must exist that were created by the city employees that demonstrate the actual knowledge. And since there's actual knowledge, there's no substantial prejudice. He didn't submit an affidavit about anything. He just let his lawyer file a pleading, a verified application. The city opposed the late filing, and the Supreme Court granted the petition allowing the late notice of claim, proving the late filing. Similarly, in Jamie versus City of New York, Jamie claims that in June of 2019 and October of 2020, he was in Rikers Island as a prisoner. And while he was there, he was attacked by inmates and or corrections officers. He was injured, even though he told the officers allegedly that he was in danger and they had to put him in protective custody or else he'd be hurt. So he claims that they acted with deliberate indifference. He didn't attach any affidavits or evidence either. He claimed that the corrections officers, who are city employees, they know what they did, and therefore the city has actual knowledge because a city employee knows what they did. He claims that there are records that show actual knowledge. The city had once again opposed, and the Supreme Court allowed the late filing. In each case, the court allowed the late filing, and the appellate division affirmed, saying the city had acquired actual knowledge due to the fact that the officers who participated in the conduct are in possession of the records and they know what they did. It goes to the Court of Appeals, and they say this is wrong. They reverse the appellate division. They reverse the Supreme Court in each of these cases. They say the purpose of the notice of claim is to alert the municipality of the existence of the claim so they can investigate and possibly preserve evidence. They have a right to compel oral and physical examinations. And they say while the courts have broad discretion, it's not unfettered discretion. And they have to consider these factors as to whether one of the factors is whether the municipality has actual knowledge. Courts should not assume that every single municipal officer and employee has actual knowledge, because that would basically vitiate this protection. So they say the real question is there knowledge of essential facts as to time and place by an actor in a position to investigate? So not a rogue police officer. If you claim a rogue police officer did something crazy, that's not actual knowledge by the city. If you say that an investigating officer or the IAB or CCRB or, the equivalent of basically who would be informed if you filed a notice of claim, if someone who had a reason to investigate it knew, now you're talking about actual knowledge. But just to say that an employee of the city knew, so the city should know, is not accurate according to the Court of Appeals. And as to the contents of records, because one of the claims that each of these petitioners made was there's proof in the records. They say while the contents of records can be sufficient to show actual knowledge, simply alleging that records exist that show the information is not sufficient. So unsubstantiated and conclusory allegations that a municipality acquired timely knowledge is not sufficient, and neither is a claim that there are some records out there that show what actually happened. And he's also, while it's not determinative, petitioners should be showing that the late notice does not result in substantial prejudice. Here, they didn't do that. So in each of these cases, they go through then that analysis and say, each of these cases, Orozco and Jamie failed to provide an affidavit, which would be personal knowledge by a person that the claim actually happened. They didn't provide that. And there's no proof that any individual who would be responsible to investigate this knew about this. And they didn't include any documentary support that anyone had actual knowledge. And while that's not determinative, that's an important factor in the multi-factor analysis. And because each of these Supreme Courts who were deciding whether there was a sufficient basis to excuse the late notice of claim didn't have anything beside these allegations and assertions, there was insufficient as a matter of law. And it was an abuse of discretion to allow it. So they reverse it. This was not proper. They shouldn't have properly allowed the notice of claim that was late. And that's the case of Jamie versus City of New York and Orozco versus City of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.